Good day. Now I'll be explaining the introduction to trademarks in Malaysia, UK and US. A trademark is any sign, such as a word, logo, sound, color or shape that identifies and distinguishes the goods or services of one party from another. It helps consumers recognize the source and quality of a product or service. To be registrable, a trademark must be distinctive and not descriptive. In Malaysia, trademarks are registered through MyIPO. Registration is optional but gives stronger legal rights. Protection lasts 10 years renewable indefinitely. Marks unused for 3 years may be cancelled. Enforcement follows the TRIPS agreement. Moreover, in United Kingdom, it is registered through the UK IPO. A wide range of mark types is allowed, such as logos, sounds, holograms, and many more. Protection is for 10 years renewable. Unregistered marks can rely on passing off, but registration provides clearer rights. Supports international filings under the Madrid Protocol. Meanwhile, United States trademark rights begin upon use in commerce. Registration with the USPTO grants stronger nationwide rights. Symbols such as TM for goods and SM for services, especially unregistered, and R for registered marks. Registration is optional but recommended. Marks unused for 3 years risk losing protection.
Now I would like to present the absolute grounds for reversal of trademark registration in Malaysia. What are absolute grounds? They are problems with the trademark itself, without looking at other marks. The trademark must be clear and able to show that it belongs to one business. Section 23 Clause 1 Clause 8 says that a trademark cannot be registered if it cannot be clearly shown or cannot distinguish one business goods or services from another's. Section 23 Clause 1 Clause B says that a trademark cannot be registered if it lacks distinctiveness. A trademark must be unique enough for consumers to recognize that it is different from others. If it is too common or ordinary, it cannot be registered. The third ground is the Section 23 Clause 1 Clause C, which is that a trademark cannot be registered if the trademark is composed of descriptive marks. Words that only describe the goods or services like their type, quality, or purpose cannot be registered. This is because these words need to be available for every day to be used fairly. Section 23 Clause 1 Clause D stated that a common or generic signs cannot be registered as trademarks. This is because marks made up entirely of signs or words that are already commonly used in the industry before the application cannot be registered. This prevents anyone from taking exclusive rights over common terms. However, there is an exception to the absolute ground, which is stated under Section 23 Clause 2 of the Trademarks Act, where it stated that the trademark can be registered if it acquires distinctiveness. This means that even if a mark is descriptive or not unique at first, it can still be registered if it has become well known to consumers in Malaysia before applying. This means that people can recognize a mark as belonging to one particular business because of its long use. Now I would like to discuss the relative ground for reversal of trademark registration in Malaysia. What are relative grounds? Relative grounds look at how a new trademark might affect older trademarks. The main goal is to prevent public confusion. Section 24 Clause 1 of the Trademark Act said that a trademark cannot be registered if it is similar with earlier trademarks. A new trademark can be refused if it is the same or very similar to an earlier trademark used for the same or similar goods or services. Even if a trademark is famous for one product, it can be refused for other related products if confusion might happen. The second ground is stated under Section 24 Clause 2 of the Trademark Act, where it stated that a trademark cannot be registered if it is likely to cause confusion. The registrar will refuse registration if the new trademark might confuse the public, making them think that the goods or services come from the same business. Factors considered include how similar the trademarks look and sound, how unique the older trademark is, and who the customers are and how carefully they pay attention. In the case of Palm Gold Leisure versus Palm Gold Corporation, the court found that the first user of the Palm Gold trademark was the defendant instead of the plaintiff, as he used it since 1990, before the plaintiff changed their company name to Palm Gold Leisure in 1996. So, the defendant acquired the trademark rights. The last ground is a well-known trademark which is stated under Section 4 Clause 1 and Section 24 Clause 3 of the Trademark Act. A well-known trademark is one recognized by many people, and the registrar must refuse a new trademark if it is the same or similar to a well-known trademark for the same goods or services, or it is the same or similar to a well-known trademark for different goods or services but might cause confusion or harm the well-known trademark's reputation. In the case of White-Tech Autumn Pass versus S1R Global Holding, S1R Global Holding owned a well-known S1R mark for lubricants. White-Tech registered the same marks for other goods. The court ruled that White-Tech marks should be removed because it should cause confusion. This case supports the rules that trademarks causing confusion can be refused or cancelled. This case is judged under the Trademarks Act 1976, but the same principle applies under the current 2019 Act.
Now I would like to present my part, which is the absolute grounds for reversal of trademark registration under the United Kingdom. Firstly, the part is the lack of distinctiveness. A trademark must show a business, goods or service are different from others, which is the common words like the banana for banana cannot be registered. Secondly, non-traditional marks. For the non-traditional marks, for example like the shapes, colors and sounds, must also be different and special. And it is harder to prove that if the mark is not natural uniques. For example, in the case of the Nestle tried to register the shape of the Kit Kat bar, but it was refused because it was proven not to be spacious. Thirdly, the point is the descriptive of all the common terms. Marks that only describe the product types, quality, purpose of origins cannot also be registered under the trademark of the United Kingdom. Fourth, the point is the adequate distinctiveness. A mark that will not different at first may be accepted if the people have come to recognize it as showing where the product comes from. 5. The point which is the inverted or arbitrary marks are better. In this point, it's stated that the made-up or unrealistic words like the marks for chocolates are easy to register, logo and design, and can also help the trademark become more special. Therefore, it can be easy to be registered under the trademark of the United Kingdom. 6. Surnames, shapes, and colors. They are harder to register unless they are clearly stand out and people can knowing them this is the source of goods. Only the unusual shapes or color used for a long time may be accepted. 7. The point which is the clear representation needed. The trademark must be shown clearly by using the pictures or sound like the JPEG for logos or the MP3 for sounds. Both are the public and the trademark office must be understand exactly what is protected. 8. The point is come to the protected geographical names, which is the PGIS and PDOS. Names like the cornice-pasty or the Stilton cheese cannot be registered because they are protected. They are stopped similar trademark from being registered under the United Kingdom. The last point is the bad faith applications. If someone applies for a trademark in a dishonest way, for example, they try to copy another brand or applying without real plans to use it, the application will be rejected under the trademark of the application of the United Kingdom. Thank you. Now I would like to present my part, which is the relative grounds for the reversal of trademark registration under the United Kingdom. Firstly, if it conflicts with the era trademarks, a trademark application can be refused if it is the same or very similar to the era trademarks used for the same or similar good or service, and this could lead to refusal under the registration of the United Kingdom. Secondly, confusing similarity. Even if the new trademark is not exactly the same but looks or sounds similar to an early one or familiar or similar to the good or service, it also may lead to refusal. Thirdly, the well-known trademark. A new trademark can be refused if it was similar to famous or well-known trademarks in the United Kingdom, even if the goods or service are different, especially if the new trademark unfairly treated or take the benefits from or harms the old trademark reputations. Other legal rights also is the main factor lead to the refusal of the trademark registration under the United Kingdom. A trademark can be refused if a third party has legal rights like the common law rights or other intellectual property rights that prevent the use of the new trademarks. Unregistered trademark also is the main point to lead to reversal of the trademark registrations. For unregistered trademark, the era trademark must have been used commercially or recognized by the public beyond a small local area to block the new trademarks. Next, similarity to the good or service. Good or service are compared by their nature, customer, how they use, and if they compete or complement each other. Being in the same classifications of the trademark does not automatically make them similar. The last point is the unfair advantage or damage to their reputations. A trademark may be refused if it is unfairly benefit or harms the reputations of an already well-known trademark in the United Kingdom. Thank you. Now I would like to present my part, which is the grounds of the trademark reversal in the United States of the Americas. The United States Patents Trademarks Office may refuse the federal trademarks registrations based on the several grounds primarily outlined in the Lanham Acts. Firstly, in the parts of the absolute grounds of the refusal, which is the immoral or scandalous marks historically, under the sections 2 clause A of the Lanham Act originally bans the immoral, deceptive, scandalous or disparaging marks. However, in the 2019, the Supreme Court case in the case of the Lancho versus Bernardi struck down the ban on immoral or scandalous marks as an unconstitutional restriction on free speech that allowing the registration of marks like food. Secondly, under the section 2 Clause B of the Landmarks Act, The government insignia marks resembling flags, coats of arms, or other government insignia are not registrable to present the false endorsement. However, the flags of former countries, states, or municipalities can be registered. Thirdly, under the Section 2 Clause C of the Lanham Act, in this section, it's illustrated that the names, portrait of living individual require written consents for marks using a living individual names, portrait, or signatures. This also applies to the deceased United States presidents and widely recognized individual even if only a partial name is used. Now I would like to present the part which is Section Clause E of the Lanham Act, and this section is meaning that the types of marks that are hard or impossible to register. Firstly, which is the merely descriptive. This mark just describe a quality or feature of the products. And for example, the study of portraits. And it can be registered only if the people have come to connect with the words with your brand, and this is called the secondary meaning. Next, which is the distinctively misdescriptive. And in this part, it means that this mark can give a false idea about the product features. For example, real oak for chairs that aren't made of oak, and it can be registered only if they are the secondary meaning. Thirdly, which is the deceptive marks, and these marks are meant to trick the customer and actually fool them. It means that it trick them or it's trick them. And for example, this is the meaning of saying something is organic, however, which is not, and it can never be registered. Fourthly, which is a geographical descriptive. In this meaning, it means that this mark are tell where the product is really from. For example, the Napa Valley wine is from the Napa Valley, and it can be registered only if they are the secondary meanings. Next is the geographic deceptive misdescriptive, and these marks wrongly suggest the product comes from the certain place. And for example, the London Dairy is from the milk from Brazil, and it cannot be registered. Next, which is the primary assurance. These marks can be mainly just for last name. For example, Johnson for furniture, and it can be registered only if they have the secondary meanings. Next, which is the functional. These marks are based only on how a product works or what it does. For example, a specific handle shapes that makes a tool work better, and it can never be registered under the trademark of the United States. Thank you.
Now I'm going to discuss the relative ground for reversal of trademark registration in United States. Section 2 Clause D of the Lanham Act prohibits registration of a mark that is confusingly similar to an existing registered or previously used marks. The concern here is the likelihood of confusion, not the actual confusion. And this is the most common reason for the United States Patents and Trademarks Office refusal, as the similarity can be in appearance, sound, meaning, or commercial impression. The DuPont factors help to assess this likelihood. The first factor is the similarity of the marks. It examines the similarity in appearance, sound, meaning, and commercial impression. Even minor differences in spelling or fonts may not be enough to prevent confusion if the marks, sounds are similar to or convey the same meaning. For example, cleans versus clean. The second factor is the relativeness of goods or services. As USPTO, they consider if the goods or services associated with the marks are related in the eyes of the consumers. The next ground is the degree of consumer care. For expensive or specialized goods, consumers typically exercise more care, reducing confusion. For inexpensive or everyday conducts, less care increases the risk of confusion. The last ground is the actual confusion or coexistence. Evidence of consumers mistaking one mark for another strengthens the refusal agreement. Conversely, evidence of coexistence without confusion in similar markets can argue against a likelihood confusion.
So, to conclude, trademark laws in Malaysia, the United Kingdom, and the United States all aim to protect brand identity and prevent consumer confusion. But each country applies its own legal framework with specific grounds for refusal. In Malaysia, under the Trademarks Act 2019, the focus is on ensuring that a mark is distinctive, not deceptive, and not against public interest. In the UK, through the Trademarks Act 1994, assess both absolute and relative grounds for refusal, such as whether the mark is immoral or conflicts with earlier rights. In the United States, the Lanham Act requires actual use in commerce and closely examines whether a new mark might cause confusion with existing ones. Although their procedures differ, all three systems share a common goal: to maintain fairness in the market and protect both consumers and business. So, for anyone looking to register trademarks internationally, it's essential to understand these jurisdictions' specific rules to ensure a smoother registration process and stronger brand protection.